Hello folks and welcome back to the Sovereignty Masterclass. I hope you're all doing very well. In this video, or series of videos I'm going to be doing, we're going to be reading through an amazing PDF I managed to get my hands on that I've gone through multiple times. I just had to put it out there for you guys for us to work through in order to better our understanding when it comes to estate planning, asset protection and trust management by a gentleman called Carlton Weiss, which is called obviously Weiss's Concise Trustee Handbook, which is a guide to the administration of an express trust under the common law, functioning under the general law merchant. So I want you guys to really supplement this with the videos that I've done previously on the common law private trust, with all the templates, breaking down all the methodology, right, and how we can go about administering, setting this entity up, right? So we've got a few options. We can either have a third party trustee, which is a trust expert, a legal attorney at law, who can administer, or someone, your friend or another family member who is sui juris, who has the capacity to be able to administer this for you on your behalf as the grantor and beneficiary. Or you can set it up as the grantor yourself, become the trustee, and basically be afforded all the natural rights of a private individual or private living man or woman, as well as using this entity in the commercial world as also a natural person, which is recognized within that system, in order to use that as a vehicle to get things done in the world of commerce, where you have beneficiaries that are obviously separate to yourself. And so breaking this down and going through this book, it'd be really beneficial for you in order to get to that point of understanding where we become sui juris. So I recommend obviously working with this through this video with me, going back and watching the previous videos on the common law private trusts, breaking down the templates too, sit down and listen through all of it. I know it's like watching paint dry, but trust me, it will pay huge dividends for you in the future when you embody this knowledge. You know exactly how to set up these entities and operate these entities on the private and public side. And then also there's another video and another book that I recommend you guys go off and read and watch under the introduction module if you haven't seen already those inside the course, is Be the One to Execute Your Trust by David E. Robinson. If you get these materials embedded and embodied within your person, within your being, and know this off the back of your hand, there's no stopping you. You're going to be complete sui juris. You'll be able to know exactly what's going on with the game in terms of the legal system, the lawful system, and the monetary system with fiat debt currencies, and what is legal tender and what is actually lawful money of the land, portable currency, etc., portable land, which is gold and silver. So it just really helped build on itself, get you guys to the point where you can start forming your whole 360-degree view of how to become a sui juris. So it's like the hub of the wheel. Every time you go back, even I go back and watch my own presentations, right? Because I learn something new every time. And so it's a never-ending kind of spiral of us going back and putting more spokes in the wheel. So you've got the main hub, right, which is our mission of becoming, with this wheel, this holistic approach of law and everything we're trying to do in this legal realm with sovereignty, becoming a sui juris, is that every time you go back and keep embedding and going over and researching and studying, you're adding more spokes to the wheel. And then once you have all these spokes in place, you've got a 360-degree view. You are a sui juris. You're able to then use that vehicle, right? It's a good analogy for a wheel to maneuver in the seas, the law of the sea and the law of the land, in the public and the private realm. So that's quite a good analogy actually I worked out to be, in terms of thinking about just keep adding spokes to the wheel. Add spokes to the wheel. Once you get to that point where it's structured, you know exactly what's going on, you can go away with confidence, set up these entities, knowing exactly what you're doing as a sui juris. This is what sovereignty means, is to be the embodiment of an expert in a particular field of study, rather than what this system tries to do with compartmentalizing everyone to be a specialist in something, where they're taught more and more about less and less, basically until they know everything about nothing. And that's the kind of schism that we're in. We've got all these bloody experts that are like in a magnifying glass, but they're forgetting to see the whole picture of what it takes, what is needed to become a sovereign, a holistic practitioner on this planet. Okay, which is why I got kind of like a bit of a grudge against the so-called holistic health practitioners. I know it's under health, but a holistic practitioner should embody, you know, health, wealth, and law in every aspect of life, psychology, you name it. Okay, and that's where obviously a lot of guys come short with the holistic practitioner approach, is they're missing the money and the lawful side of things with, you know, what we're doing here in the Sovereignty Masterclass. Okay, so sit tight, get comfortable, grab a drink. I will break this down into, like, you know, shorter bite-sized pieces, because even though he makes it very, you know, succinct, there is, you know, up to about 40 pages before he then goes into the templates, which, you know, you guys can go through in your own time. But it's so good, it's really well written, and it's got a wealth of resources to back with the references that you guys are encouraged as well to go off and read through in your own time. Okay, so those obviously inside the course and Sovereignty Masterclass. If you're watching this on YouTube, you can head to my website agmiddleditch.com and sign up and get your hands on all the trust templates in terms of the common law trust that otherwise, you know, you'll see will be a part of how to administer and set up one of these express trusts. But for those on the course, obviously you've got access to this PDF down below in the Dropbox link, and then obviously as part of this module, you've got access to all the trust indenture templates, etc., etc. Okay, so I will leave a link down below in my YouTube video for those to actually access this also, because it's obviously fair use, free sourced online. Okay, which I highly recommend. So here we go. Let's go straight into it. So, introduction. He says, this handbook is about the administration of express trusts created under the original American common law and functioning within the unique system of commerce in the American states, i.e. the general law merchant, as it stands in 21st century America. Now, just a quick side note, even though this is obviously geared towards, you know, being written in America, because America is so fresh in regards to the Constitution, how that was founded on the common law right of contract, okay, which obviously came out of England back in the day, this applies anywhere you are in the world, because it is our fundamental unalienable right gifted to us by our Creator in order to get together as a man to man or man to woman, whatever, to formulate entities like this, like a trust, okay, and come together and contract in that sense and set up these entities for our benefit, okay, which no state will be able to intervene in if it is set up properly and managed properly. Okay, so it's a non-statutory trust, and obviously this book will go through and highlight all the benefits that are afforded to us when we learn how to administer it effectively on the private and public side. Okay, so no matter where you are in the world, you'll still be able to apply these principles, set up this entity, because it's all formulated under our common law right of contracting with another living being, okay, which is bestowed to us by our Creator. So to continue, the material presented herein has been reduced from various sources which the reader is encouraged to examine for his knowledge and further understanding. The material herein has been rendered into a concise handbook format intended to allow the reader to refer to each section for guidance and decisions regarding the most pertinent aspects of the administration of an express trust. So, only secondary attention has been given to all other matters. All in all, the author's objective by this handbook is to devise a simple guide with clearly outlined methods and sample forms for the effective handling of affairs of express trusts, while also showing the many options for growth and prosperity and profound protections afforded by express trusts when created and administered properly. This book is written in a somewhat unconventional manner in order to accommodate this objective. If the reader should find, after examining the sources, that this work has failed in its objective, then let it be attributed to a fault of the author, not to any supposed faultiness of the sources or the express trust itself. It will be admitted by all honest and learned lawyers, as it once was when a lawyer, by definition, was learned in the law, and we'll go to these footnotes in a second, that the express trust, especially one created with proper care to its instruments, is a far superior form of security or organisation in general for individuals who desire to exercise their natural rights. Okay, so we got here just highlighting under footnote 1, where he mentions, you know, the express trust created under the original American common law and functioning with the unique system of commerce in the American states, i.e. the general law merchant. Go down and read this. The general law merchant is embraced under general common law, i.e. the original and unique system of commercial law in the American states, in which there is no commerce regulation of express trusts except in connection with income derived from corporate stock and physical franchises, okay, under their articles of the Constitution. You could go away and see that for yourself and do your research with these references. And so all it's saying is that, it's basically treated as a non-statutory trust. It can't be joined or come under the jurisdiction of, the maritime admiralty commercial system unless they have an income that's derived from corporate stock and physical franchises. Okay, so you can create this entity to be separate from that and not to partake in commerce and otherwise be seen by the state as receiving benefits and privileges of the system, which means that you're implied contracting in with their system as a beneficiary, which makes you fall under their jurisdiction. So you've got to be very careful when it comes to managing this, which obviously this PDF will shed more light on in order to avoid these things, these traps, which will obviously get us to contract with them. So we have obviously here footnote 2 talking about lawyers and how they should be learning the law, which is quite interesting. It was strongly held belief of US Supreme Court Chief Justice Warren E. Burger that 75 to 90% of all trial lawyers are either incompetent, dishonest, or both. Okay, so I've gone through this document and just highlighted certain things that I feel is salient to kind of like highlight in order to emphasize, right? So, feel free to go through it in your own time. Obviously, I'll leave a copy of my highlighted PDF as well as a PDF that has no highlights, so you can go through and obviously do your own thing. All right, so here we go. Trust basics. First, it must be understood that any trust, regardless of the many designations applied to them, is, in its most basic sense, a property interest held by one person, the trustee, at the request of another, which is the settlor or grantor or executor, for the benefit of a third party, which is the beneficiary. The classification applied to a trust is based primarily upon its mode of creation, in which it may be created either by act of a party or by operation of the law. In the case of the former, trusts are divided into two types. We have express or implied. You can see a little breakdown here in the chart. Without getting into the various subclasses of express and implied trusts, the basic difference between one created by express act of a party and one created by implied act of a party is that the former is stated fully in language, oral or written, while the latter is inferred solely from the conduct of the parties. These are very generalized definitions, so presented for want of space, since there are many intricacies concerning the true meaning of the term implied. It has been shown that, in a sense, the classification of express trust can only be applied based on what is implied by the language of the instrument which created the trust. So we won't get into that. Our focus is on a particular written express trust type, and even though the above definition is essentially accurate, it does little to define the express trust as it is known in its fullest sense under the protections of the common law. Okay, so express trust is basically, it's written, and this is what we're teaching here and advocating, and obviously in the previous videos with the common law express trust is done in writing with the trust indentures and all the agreements. Okay, so it's an actual lawful common law contract. Okay, whereas, there are other forms of trust that can be performed upon under the operation of either the law, which is obviously what's happening in the courts of a constructive trust based on the actions of the individual, locking them in to perform in order to formulate a constructive trust, which is obviously where a lot of the legal tricks and traps are being played, where they subrogate us, make us trustee, and then the state becomes a beneficiary, which they use our name as the Social Security Trust Fund, and then the judge is the executor, and he obviously charges us with performing because we haven't been able to perform through breach of trust on behalf of the beneficiaries, which is the state. Okay, so it's a minefield, but we're focusing especially here with this entity as an express written coming together, a contract formulating this common law private trust or express trust in this sense. So we continue. Express trust under the common law. The most adequate definition of the express trust is to be understood from the earlier case law, which has been eloquently summed up and restated into a clear, concise definition by Alfred D. Chandler, Esquire, in a report submitted to the tax commissioners of Massachusetts on unincorporated associations. His study was conducted as part of a legislative investigation into their economic effect on the state in 1911. In the first part of the report, at pages 6 and 7, he offers the following definition. Express trusts put the legal estate entirely in one or more persons, while others have a beneficial interest in and out of same, but are neither partners nor agents. This simple, adequate common law right, any person or group of persons sui juris may exercise. The trustees issuing certificates of beneficial and capital interest divided into shares, as well as issuing bonds and other obligations as freely as they open a bank account, have a passbook, and draw and circulate checks, or make whatever contractual relations are allowed to persons as a natural right. Okay, so what becomes clear from this definition is that the express trust is not merely a property interest held by one for the benefit of another, like any basic trust. Rather, it is a trust created by private contract for the holding of a divisible property interest, wherein the trustee is empowered by the settlor, the grantor, to do for a beneficiary of his, the trustee's, choosing whatever he may do for himself as an individual sui juris. Okay, what has been created here is a trust organisation lawfully by natural right. So as a general proposition, it may be asserted that one who creates a trust may mould it into whatever form he pleases, and that whatever one may lawfully do himself, he may authorise another to do for him. Doing so requires no benefit, privilege, or franchise from any government or other outside party, and therefore the parties owe no duty to any government or other outside party to the extent that no common law criminal or civil wrong is the purpose of the contract. When done properly, the trust is afforded all the common law protections ordinarily given to private contracts, particularly the obligation of them. Now, the question is whether the parties to the contract are truly acting sui juris, i.e. of their pure, unadulterated common law natural rights. Because if the parties import or associate benefits which grant an outside party a vested interest in the proposed contract, then the contract has acquired a third party overseer / intervener. Okay, and we'll just look at some of these footnotes which help elaborate on some of these points. On footnote number 7, okay, up here where it's explaining about the unincorporated associations, we'll just read this highlighted text, which is a court case. The court made it clear that a pure express trust, active and functioning as such, has standing in law as a trust and not an association. Okay, and these words again are very key in terms of what you're labeling and how you're performing, like how you're acting as this entity. If you're intended to put together a common law express trust, private trust, you must perform and have the actions and the things in place that otherwise are affiliated to being treated as such, and not an association, which then can capture you under their jurisdiction. Okay, so you've got footnote 8 here, where they mention, let's just have a little skim about the sui juris. Okay, so the simple, adequate common law right any person or group of persons sui juris may exercise. Okay, so this is the power that when you set up this entity and you yourself become the trustee, then you can basically, under the trust indenture, as long as it's allowed and written in the indentures, which is your powers, what bestowed to the trustees, in terms of the terms and conditions of the trust, that they have powers to do, then you could do anything a sui juris would do in their own private capacity, but just use the trust entity as otherwise a veil and a vehicle in which to get things done through the whole concept of, owning nothing but controlling everything and being protected. Okay, so it says here, this is defined as of his own right, not under any legal disability or the power of another or guardianship, having capacity to manage one's own affairs, not under legal disability to act for oneself. Okay, like David E. Robinson emphasizes as well, be the one to execute your trust. You must learn all about this, guys, if you want to truly become, a sovereign being in the spirit. But, sui juris is the correct term in the lawful language to administer your own estate. Okay, so we have here footnote number 9, again emphasizing, let's just read this again. Rather, it is a trust created by private contract for the holding of a divisible property interest, wherein the trustee is empowered by the settlor to do for a beneficiary of his, the trustees, choosing whatever he may do for himself as an individual sui juris. Okay, so just emphasizing that point before, that we have the freedom to do all of this. Okay, so we just read the highlighted text, which says, it has long been held that trustees of express trusts have greater latitude than ordinary trustees, simply because such trusts, created by individuals sui juris, may do whatever individual sui juris may do. Okay, and if you recall back in the previous videos, when you are acting as trustee, you can be compensated for your administration of the trust, and that can be up to $500 a day, and that can be seen as being tax exempt under the eyes of the law under some court cases that are quoted in those notes that I share with you guys. Okay, and you can otherwise just use this entity, this trust, as a vehicle for you to go about and do all of your daily business, private business and public business. Okay, just being careful not to, take on the benefits of the system from a third party, overseer and intervener. But this is why we shared in the previous video, this whole harmless indemnity agreements and agreements in place for authorized representatives in order to, contract with the public realm for these attorneys and these other people if you want to get work done, in order to then still have that limited liability upon you as the trustee. You can't, be dragged into their jurisdiction and get in trouble unless there has been, a common law injury of infringement on the rights, life, liberties and properties of another individual, or breach of trust within the trust itself between you as the trustee and the beneficiaries. Okay, and that can be brought into court by the beneficiaries if you as a trustee have not been acting in your lawful capacity, in your responsible lawful capacity for the benefit of the beneficiaries. Okay, if there's any negligence there or fraud, etc. Okay, commingling, all of this. Okay, this will be mentioned later, but it's very rare that these kind of trusts are penetrated and broken down. Basically, the only way it can happen is from within, based on the trustee's maladaptive behaviour, okay, and fraudulent activities, basically. So it's all down to you. If you do something wrong, which would be pretty obvious if you do any injurious crimes to any other living being through the trust, or you start using the trust as like a commingling alter ego entity, where you're mingling your personal assets with the trust assets, then yeah, it can be seen as like an alter ego in the courts, basically, and it can just be dismantled. Okay, so silly things like that, which you guys, if you are sui juris and you're up to speed with all this, especially anyone kind of coming into this knowledge, it would be very rare that you would have an individual that's that reckless and going about destroying their own private trust entity, which is very, very beneficial to have and maintain. So we continue. Declaration of the expressed trust. So the declaration of trust is the trust instrument that constitutes the trust. It has been noted in trust law that no technical expressions are required to create a valid declaration, so long as the words used make clear the settlor's intent to create the trust or confer a benefit of some sort that will be best carried out in the form of a trust. A trust instrument doesn't necessarily need to be a declaration either, for a trust may be, and often is, formed out of a simple agreement or even a will. But with an express trust, the declaration has been preferred since the beginnings of trusts under the common law of England, which otherwise shunned fictions of law. Okay, we know you guys on this journey, fictions of law is how they're getting us to contract into and under their jurisdiction by making us join their accommodating parties to all these vehicles that they set up under the legal system, which is the corporate system, the commercial world, right? Maritime admiralty, all these vessels being floated on the sea of space across the lands, where they brought the waters up over the lands, and got us all labelled as vessels in rem, which is otherwise things, and they managed to get us to treat us as in rem, which is obviously objects or things or chattel, stock, livestock like horses and sheep, via the impersonum, okay, which is via these personas in the legal system, such as the strawman, okay, and all these corporate entities. And so through that, they managed to get us into their fictions of law, the colouring of the law, okay, which we all know about, the language, and many other tricks and traps that we've gone through in this course. Okay, so that's just important to highlight there. This is why careful attention to detail is most crucial, because in order to properly construe the intent of the settlor, the objects, property, and manner in which all is to be carried out must be set forth in unambiguous, precise language, so as to particularly create the express trust. And where the intent of the settlers is unclear, under equity, interpretation is required to construe the intent of the parties, and the trust may be deemed invalid depending on the degree of ambiguity. However, when all is done properly, obviously there can be no lawful impairment of the obligations of contract. Okay, so just making sure you're dotting your I's and crossing your T's, and it explains very clearly what it is you're doing in the trust declaration or the trust indenture, it's commonly referred to. So let's just go through some of these footnotes in order to assist us in our understanding as to what is going on. So for number 13, We'll just read the highlighted text. You can read, the stuff before that in your own time, just to save time on here for you guys. When done properly, the trust is afforded all the common law protections ordinarily given to private contracts, particularly the obligation of them. Okay, so number 13, we'll just read here in Elliott versus Freeman, 2020 US 178 1911. The court made it clear that the express trust is not subject to legislative control. It went further to acknowledge the right-wise stance of the United States Supreme Court that the trust relationship comes under the realm of equity based upon the common law right of contract and is not subject to legislative restrictions, as are corporations and other organizations created by legislative authority. Okay, so it doesn't come under the realm when formulated correctly and administered correctly, doesn't come under the realm of corporate jurisdiction, and it's otherwise under the realm of equity based upon the common law right of contract. Okay, so we have here number 15, and so we might as well read on. So to clarify the equity and common law distinctions, the basis for express trust under the common law in this instance is not that such organizations are creatures of common law as distinguished from equity, but they are created under the common law of contracts and do not depend upon any statutes. Okay, so if you're administering your trust correctly and you get into a lawsuit and you want to bring action through the court system, it will be under the court of equity, because this is a common law vehicle that was formulated under the common law right of private contracts. You will not be subject to the statutory maritime admiralty jurisdiction of their foreign vessels and dry dock courts. Okay, you'll be put in front of a chancery, an equitable judge, in order to seek remedy, because you're doing all the right things in regards to making sure you're not contracting into the system through third parties, or how you're performing as a trustee on behalf of the trust, okay, and seeking income from corporate stocks, etc. All right, so that's so very important. And so, equity compels performance, and going to make sure you're always performing on the private side under the common law right contract and the common law maxims of law too, which is closely tied to equity as compared to common law, which is made under the law merchants. So we've got number 15, footnote here, which is the declaration of trust. A quick note: this is sometimes referred to as the trust indenture for the purpose of denoting that it outlines the terms and conditions governing the conduct of the trustee as an indentured servant to the beneficiary under contractual arrangement, referred to in this sense as indenture trustee. Okay, that's what we emphasised. Right, to carry on. Moreover, the declaration, by its terms and provisions, serves to establish the entire contractual arrangement, including the identities and positions of the parties, the trust name, jurisdiction and situs, and all particulars of administration, all of which the courts of equity will fully support by the principle that equity compels performance, which is what I mentioned. The ultimate result is the creation of a bona fide legal entity with its own separate and distinct juridical personality, with standing to sue and be sued, and to function as a person in commerce by and through its trustees. The term natural person has been applied to express trust by courts of equity because of its administration being carried out by men acting as natural persons. Okay, under this application, the trust's right of contract is alienable, whereas its creator's natural right of contract obviously is not. The express trust nevertheless possesses, inter alia, the right to all enjoyments stemming from the contracts into which it enters, as well as the obligations imposed under such contracts. The express trust possesses the ability to hold, own property, engage in business transactions, and incur liabilities, including tax liabilities, as well as assume creditorship, including secured party status, like any other legal person. So we just emphasise here with the footnotes, which is, I think really prevalent to hit home the point of like the in rem jurisdiction and the kind of fictional law system, the colouring of the law system that they've, got us to joinder into, which is obviously made very obvious in America with, what has happened quite recently, because it's all very fresh for them. It's happened in the UK, I think, back in the 17th century when the Bank of England was set up, whereas, in America it's still very fresh. When the Crown and all these international bankers went over and took over their system of the Constitution and took everyone away and treat them as legal fiction. So number 24, let's just read this. So, and to function as a person in commerce by and through its trustees. The term natural person has been applied to express trust by courts of equity because of its administration being carried out by men acting as natural persons. So we look at footnote 24, got a lot highlighted here. This is a really good one, guys. So a generally unknown fact is that there are several types of citizens now existing in America, or wherever you are. Okay, the trustee of an express trust may seek protection under the constitutions as state citizens throughout the Union of States, a jurisdiction outside the scope of the 14th Amendment, which we will discuss in a later section. Now, the 14th Amendment basically turns everyone into a taxpayer, citizen of the federally chartered bankrupt corporation, as otherwise known as the United States of America. So if you look at USC, I think it's 28 USC 3002 subsection 15A, it does actually state that the United States is a federal corporation. So if you're coming in as a citizen of that federal corporation under bankruptcy law, you are considered nothing more than a person. A person is otherwise a straw man in law, in the legal system, that has no natural unalienable rights. Okay, and you'd be treated as a sole proprietorship, and you'd be pledged as surety and collateral for all the debt in the system. Okay, so it's a very cunning and covert system that's in play in order to make everyone surety and accommodating parties for these legal fictions in order to help pay off a debt which can never be paid off because you're only using promissory notes, which is an event that's going to happen in the future. It's gambling proceeds, it's speculation. Okay, so you're constantly in debt servitude basically. So it's a very clandestine slave system they set up through the law and the money system. So let's continue. However, it should also be noted of all citizenship, 14th Amendment or otherwise, that jurisdiction over natural and artificial persons is distinguished without a fundamental difference. This stems surprisingly from the operation of in rem jurisdiction, which underlies all civil law. Okay, so in rem means of things, which underlies all civil law. Though all courts are familiar with the action in personam, which is against persons, it is the action in rem against things, which, though practiced only in maritime law, stealthily operates in every civil and criminal court. Okay, so let's read that again because that's very, very salient. Though all courts are familiar with the action in personam, okay, against persons, it is the action in rem, which is against things, which, though practiced only in maritime law, stealthily operates in every civil and criminal court, as we know. Okay, I think it's the Clearfield Doctrine as well. If you look up the Clearfield Doctrine, I think back in 2008, they'd actually used a court case that otherwise basically stated that every court is now operating under this in rem maritime admiralty jurisdiction of treating everyone as things. Okay, nothing more than fucking horses, shipping vessels, etc. Okay, so as it goes on to explain, the principle is one of the least understood in its entirety. In rem jurisdiction over a man or woman can only exist if the man or woman is a slave, i.e. property or res, an object, in which case his or her disposition at law is no different than if he or she were a horse or other goods. Okay, and it says here to see the zone, Gregson versus Gilbert court case. Okay, in nature, in rem jurisdiction is exercised over men and women by their creator exclusively. Governments can therefore gain only a fictional in rem jurisdiction over men by creating various legal devices, which is the personas in commerce, right? These masks they get us to wear, taxpayer, citizen, etc. For those men to assume limited control of, e.g. citizen, taxpayer, driver, etc., since the device is legal fiction, a falsehood made true by force of law. This persona is in fact a legal object or res. Just as in theatre, the persona, person, is separate from the man or woman playing the part. Therefore, there may be artificial persons, but not artificial men, natural persons, but not natural men. And this is in the American Law and Procedure, volume 13, chapter 5, subsection 65, pages 156, 157. So, you know, they're openly telling you what is going on and how they're going about tricking a lot of people and capturing them under this maritime admiralty and treating them as slaves, as chattel, you know, as mere horses, goods, you know, which is, you know, and they do this through the personas. So they create this persona, they make you think you're this straw man persona, right? And then because they issue these corporate documents, the state issues them, it means that they hold legal title over them, so it's their property. You actually then fall under their res. Okay, and you come under their in rem jurisdiction then, where you could be just treated as things, lifeless things, exactly the same as corporations, which is why everything's managed under this black law, black magic. That's all it is. It's all casting spells on the people and the masses through all these legal tricks and traps. But once you recognise the mechanisms that have been put in place, and the performance and function of law, and all these things that are designed to lure you in, to take on the roles of, to take you away from God's natural law, then you can see how to break the spell. It's quite easy. And obviously one of this is with an express trust, acting as trustee and having that as your shell protection in order to navigate in the private and the public. Okay, and obviously we've got other things with the state's corrections that we do with all the documents, claiming back power of attorney over a straw man, being an authorised representative, an agent for a chief executive officer, and all these things, secure party creditor, which otherwise you can have this trust entity do, as I said before. You can use this trust entity as a sui juris, as if you are operating it on your own behalf, anything you can otherwise do yourself. Okay, so it's so very powerful. So we'll continue reading on. It's got some good stuff here about, you know, the Roman history of the whole masks and what happened around that for the personas, right? So the word person defined, Gaius says, the juris divisione, the divisions of law, immediately preceding his division of the law, then follows the condition hominum, meaning the condition or status of men. In the institutes, the jura personarum precedes the expression all our civil law relates either to persons or to things or to actions. The words persona and personae did not have the meaning in Roman which attaches to homo, the individual, or man in the English. It had peculiar reference to artificial beings and the condition or status of individuals. Okay, so a lot of you guys, if you look up homo liber in the Black's Law Dictionary, the latest version, is the closest thing you're going to get in their lawful language that's going to identify you as a free being, a sovereign being, and not considered chattel, right? Which is what they had human down in one of their Black's Law definitions, in one of their editions, right? As a monster, akin to property. And this is how they've captured you, through the language is so key. It's the codes that program our conscious and subconscious minds. It's the symbol codes that control our performance in this reality. This is why it's so key to come back, when you come back to life, the roles we play is so important. And all they are just symbol codes expressed as language, obviously written on paper, but as we already speak it, it's expressed as a sound vibration wave, which otherwise what is language, what is writing, so there's a 2D representation of sound. Okay, so homo liber is actually very favourable. And I have this on one of my private IDs that I've issued to myself at my own court of office address, okay, homo liber. And so it obviously just emphasises that right here. Okay, persons, persona is linked to all this legal fiction of law, colouring of the law. Okay, putting on these different masks. And we can wear many masks as long as we're not joinder, an accommodating party to these masks that we wear, and that there is that separation. Okay, so it continues. The word person, in its primitive and natural sense, signifies the mask with which actors who played dramatic pieces in Rome and Greece covered their heads. These pieces were played in public places and afterwards in such vast amphitheatres that it was impossible for a man to make himself heard by all the spectators and later by all judges. Recourse was had to art. The head of each actor was enveloped with a mask, the figure of which represented the part he was to play, and it was so contrived that the opening for the emission of his voice made the sounds clearer and more resounding. Vox peronabat. Okay, so look that up. When the name persona, probably butchered that, when the name persona was given to the instrument or mask which facilitated the resounding of his legal voice, this name persona was afterwards applied to the part itself which the actor had undertaken to play, because the face of the mask was adopted to the age and character of him who was considered as speaking, and sometimes it was his own portrait. It is in this last sense of personage, or of the part which an individual plays, that the word persona is employed in jurisprudence, in opposition to the word man or homo. Okay, when we speak of a person, we only consider the state of the man, the part he plays in society, abstractly, without considering the individual. Okay, so we carry on. Logic follows that if the man plays no part in a society, then he has no personal attachment or obligation thereto. The trustee, under a declaration of an express trust, are only persons in the private sense, because he is only a person once he is accepting the role offered to him by the settler. Private persons may also pursue constitutional protection as natural persons, citizens within the meaning of Article 4, Section 2 of the Constitution. and may thereby claim entitlement to all the privileges and immunities of same. Okay, it quotes here another court case to back that claim. Even though in today's economic situation, the term citizen is presumed to signify the 14th Amendment citizen, the term cannot be applied to express trusts when administered properly. In contrast, corporations as artificial persons are citizens of the United States within the meaning of the 14th Amendment. Okay, so all this space is saying here is, under the common law right contract, because we are not creating this entity through the state, it's non-statutory, so it doesn't need permission and is granted life from being registered with the state, that we are afforded all the rights that otherwise are given to a so-called natural person. Okay, but I don't like the word person, so it's otherwise again labelled in the definition as someone who's a debtor. Okay, so just but in relation to obviously being able to operate in commerce, it's better than just being identified as a citizen, 14th Amendment citizen in that regard. Okay, but it can otherwise be referred to as like an individual or a man. So it has the same common law unalienable rights as would be bestowed upon an individual or man, a homo liber. Okay, so that's kind of what he's getting at with that, to emphasise, which again gives even more credence to the power of setting one of these up, which is another strategy that people can use, especially I think it's very beneficial when you have a lot of assets you wish to protect. It's very good to send the legal title, sell the beneficial interest of that and capture it into the trust in order to keep it protected, but then you as a trustee be able to enjoy it without owning it, but the trust does, okay, as a private citizen, so to speak, a state citizen, a natural person under the common law. So we have here next the trust corpus. The corpus is the body of the trust, i.e. the property being held in trust for the beneficiary, the very subject matter of the declaration. It should be noted that virtually anything may be held in trust. However, there are certain things which, given their innate traits recognised in law, make for better subject matter, so to speak. Okay, so we have anything here mentioned, footnote 26. The thing held in trust is referred to as the trust res, the subject matter of the trust. Okay, so what it's referring to, which certain things are better than others, is gold and silver. Okay, gold and silver is of the land, and that is otherwise being created by the creator. Okay, which does fall under the common law. Okay, so that's when you want to set these entities up, it's always good to be dealing with gold and silver. And as you'll see later, as we break down more of how to operate these things, these entities, is that when you buy and sell in silver and gold also, which is what Carlton Weiss encourages, you're not falling under the jurisdiction of the bankrupt corporate fiat debt currency notes of the American dollar, the UK British pound, or wherever you are in the world, because that otherwise means that if you're purchasing assets using their fiat debt currency notes, which are just literally beneficial interest certificates or trust certificate units of their trust that they've set up, okay, and their constitution and their corporate charter otherwise is, the terms and conditions of the trust, which is the legislature, the statutes, the acts, the codes, the bylaws. Once you use that and you're operating, and you're basically taking a benefit. You're benefiting via using their script that they print out on your behalf as the beneficiary. And when you claim that, you can fall under the jurisdiction. And so when you purchase any asset in their system using their fiat debt currency notes, because you're not actually physically buying it, because there is no substance backing these notes, it's all a promise to pay, and you're just extending this promise to some point in the future. Their future contracts, they're gambling. It's basically gambling. Okay, you're saying that, I'm going to acquire this asset, but I'm going to give you all these promissory notes and promise to pay that at some point in the future. It never is, because people aren't returning it to source. The only way you can do that on the public side is returning it to source using the 1099 method. The central banks, okay, who basically own the governments, the corporations, end up becoming the legal title owner of the thing you purchased with the fiat debt currency notes. Okay, so there's no way of you being able to hold the legal title. And obviously the famous saying is, possession is 9/10 of the law. And that's great. Yeah, you possess the thing like the vehicle you purchase, but you don't have legal title of the thing. They do, because you use their debt currency notes, their beneficial interest certificates, and you're acting as a beneficiary as part of their bankrupt corporate trust that they executed. And they're executing you, and because of all the tricks and traps with the legal fictions that we've just gone through the in personam, the personas that they get you to wear and take on the roles for to become accommodating parties. 2, they trap you and pull you in as things, as res, and pledge you as collateral for all the debt, and then make you the trustee. And then they execute you as the trustee has to perform under all the statutes, codes, acts, bylaws, which is just the trust indenture. It's the terms and conditions of the trust on behalf of the beneficiary, which is the state. Okay, and let's just really hit this home, because this is where it shows you exactly what's going on. The state, here we go, this is what happens on the de facto side. The judge is the executor, the state, the government's the executor. They make you the trustee on behalf of your strawman, make you think you're the straw man, and then the state becomes the beneficiaries. Okay, whereas it should be the de jure way. John, your straw man, in commerce, in their commercial world, should be instructing the state, which again, these guys are all legal fictions, but they're personas, and they're accommodating parties to their legal personas that they've taken on and pledged an oath of office to do their works and perform as their as the trustees they did take an oath for the benefit of us, the living men and women, the homos, homo labers, right, as beneficiaries. And so you got to hear the reason why they set up the Social Security Trust, the National Insurance Trust, wherever you are in the world, it's named slightly differently, is so they can capture and pretend to be you, but capture you as the beneficiary that they control, and you're now the trustee. So you can see here, power flows from the public servants, right, through the presumed public trustee, which is you, for the benefit of the state, the New World Order beneficiary of the trust. As the grantor of this trust, the federal government made the state the beneficiary of the trust in your stead and called it the John Doe Social Security Trust. That's numbered in conjunction with your name, which holds and manages your property in trust for the benefit of the state instead of for you. Okay, so if that doesn't make any sense and the light bulbs aren't going off, then I don't know, God help you. Okay, keep going over this until you get it, because this is exactly the game that's being played, which is why when you come back to life and you start playing the correct roles in terms of you being the principal beneficiary, okay, so on behalf of your straw man, you're the executor, you're the principal, and then you lock them in as trustees because you then become the beneficiary, and you order them to perform because you execute your own trust, which is what they're taking an oath of office to do. But if you just sit back and take on these roles of taxpayer, driver, citizen, you end up becoming an accommodation party, and you're basically becoming surety, and you're pledging yourself to take on the burden of the straw man, where they then make you trustee, and you're saying, yeah, I'll happily pay off all the debt that you guys are being put under from account drawn on zero balance, because it's all done by design to keep us in debt servitude, which is basically you'll never be able to pay it off from cradle to grave, and they're just going to make millions, billions off the back of your own sweat equity. Okay, and it says here, however, there is a way to separate from them and become free. Affirm the truth of your status and come out from among them and be separate. 2 Corinthians 6, chapter 6, verse 17. Okay, rebut their presumptions and be free. God knows that is the truth. Okay, so we shall continue. Hope that is, hit home, guys, because that's so important concept. Once you do really see and connect all the dots, like you got all the spokes to the hub of your wheel, connecting, it all makes sense. And then there'll be no way they can trick you. It's like learning a sleight of hand, or a magician is in front of you, but as soon as you learn that trick and how he does it with the sleight of hand and the techniques used, he can't trick you again. It's impossible unless you forget. That's the only way, which is the whole Tower of Babel incident, which goes into another story of esoteric history. But that's what they did when people started waking up. They actually scrambled the DNA through electromagnetic frequency pulses and weapons through the grids of the earth, which is the whole Tower of Babel incident, because it's otherwise the false Anunnaki gods with the people waking up when they didn't want that, didn't like that, and so they had to wipe the memory. So it's the only way we're gonna this movement's gonna be stopped. But I feel this time now is gonna be the time where we're gonna push through it of any let or hindrance those on the path and become true bona fide sovereign, true bona fide sui juris, to be able to implement this knowledge and to play them at their own game and remove yourself from the arena and actually do themselves a favour by discharging the debt dollar for dollar, which is the pledge they took ever since HGR 192, when they took away our ability to pay in gold and silver, right? So we got to learn how to play the game and operate that token piece on the Monopoly board game, right? Without us thinking that is us every time we have to perform, have that limited liability. Right, so here, carry on. Initially, The legal minds who perfected the express trust in America did so to accommodate for the great obstacles in procuring special charters for corporations intended to deal in real estate, which trusts eventually came to be known as the Massachusetts Land Trusts. It was when those individuals came to realize the immense benefits of employing the trust for the purpose of holding land that they eventually expanded their utility to include the holding of personal property. These eventually came to be known as the Massachusetts Electric Companies. As an aside, when considering the presently hostile official attitude toward non-statutory trusts, what is interesting to note is that much of the express trust perfection is attributed to Attorney General, and later United States Secretary of State Richard Olney. Okay, but the fact that the express trusts were initially primarily utilized for purposes of holding and handling real estate is very significant, especially to our present situation. The significance derives in pertinent part from the integral relationship between the law and the land. It is a fundamental principle of law that the land and the law go hand in hand. And in America, without the 14th Amendment, the law of the land is the Constitution with its common law principles and its substance of gold and silver. Okay, so that's really pertinent. Okay, so 28, we'll go down to 28 here. So referred to in this sense, it is regarded in law as portable land. The basic principle of law is that the land includes everything of value extracted from it. And this the reason why I brought up before, with the ability of paying for things in gold and silver, which is what all these private families do once they have these trust entities established, because they know that is lawful money. You can't then fall under the jurisdiction of the bankrupt corporate system of the Federal Reserve notes. You will own legal title outright, a legal title of the thing that you purchased. You actually purchase it. There's no debt incumbent upon the object that you acquired through a proxy purchase via debt notes. Okay, it's just an illusion that you purchase it, which is why they still hold legal title. You are merely a user, and they can charge you usury tax, which is otherwise just rent for you using the thing and reaping the benefits of their bankrupt fiat debt currency system as part of their trust, which is just bank beneficial interest certificates, trust certificate units. If you've got Federal Reserve notes in your pocket, you are seen a beneficiary. Okay, if you don't have your status corrected and like all these papers in order and sent in and notified and these entities set up, right? So that's why a lot of these guys, they deal in only gold and silver. They don't touch the shit that is this fiat debt currency notes, right? Because they know it's plagued, it's cursed, it's black magic. And it's just siphoning people's energy away. It's a parasite. But like I said, we can use it now for our benefit once you're on the right side of knowing what we know and what we're establishing, the things that we're doing, the 1099, and setting up these entities. So, referred to in this sense, precious metals are regarded in law as portable land. The basic principle of law holds that land includes everything of value extended from it. And without getting too deep into the operation of common law, it's this principle regarding the relationship with land and law which, by its operation, key word there, threw up an obstacle to corporate real estate ownership. In order to charter a statutory civil law entity to handle the substance of the common law land, special, if not extraordinary, legal circumstances must exist. These circumstances did not exist prior to the post-Erie federal common law, whose imposition was made possible by loss of the gold standard, the substance of the law in 1933. Okay, so it's just elaborating what we've already talked about. Let's read this footnote right now. So, see House Joint Resolution 192 of June 5th, 1933, publications 73 to 10. Prior to that, silver had already been demonetized in practice but not in fact by the Coinage Act of 1873, commonly referred to as the Crime of 73, which, it is blatantly obvious, would have been unconstitutional if done in fact. It is said to have been a tactic of Congress to place in the public mind the perception of the currency as being solely backed by gold, presumably for the purpose of the eventual passing of HJR Res 192, which Congress knew would effect a removal of the substance of law. Silver was later withdrawn from circulation in certain coins by the Coinage Act of 1964 and was removed entirely by amendment to the Coinage Act of 1964 by the Bank Holding Company Act of 1970. Then, all silver-backed certificates were discontinued in 1972. There was a big recession in 1972. So this is really tapping into like the real causes behind the economics of certain crashes that happened during this time, and the reason behind the war, in order to indebt these international banks. It was very profitable to fund both sides of the war and actually cause them to go to war. So it's all done by the same hands. They just control both sides, then indebt the nations because wars cost a lot of money, and then they get them into servitude. And then obviously anyone who's in debt with, say, a lender, the borrower is always in service to the lender, right? It's a servant to the lender, and the lender can demand that pound of flesh, because if they haven't got the ability to pay in proper money, then they can study integrate and get them to bend their arms to write the laws in order to help set up their siphoning of people's sweat equity via this removal of substance and then introduction of securities, okay, where securities have replaced substance as collateral for all the debt in the system. But under this HJR 192, because they always have to provide a remedy, otherwise it will be treason, okay, but they don't obviously advertise it. It's hidden through the 1099 process of returning, your use of the credits that they basically made a pledge that everything's prepaid, okay, for us to take you off the substance of money backed by gold and silver, and instead using debt notes, using debt, okay, and the way they did this is say that we basically are going to prepay everything for you as a result of this bankruptcy that we're in, as you are beneficiaries, okay, as a 14th Amendment citizen. But what a lot of people don't realise is that whenever they get this bill in a receipt, it's otherwise evidence of how much they've actually dipped into your trust to pay for already. It's already prepaid. That's basically a receipt to say that it's been prepaid. But you purchase the thing, and you respond to the bill or the invoice thinking you've got to pay again. That's just another offer to contract. Okay, so there's a way of actually doing them a favour by reducing the national debt, by returning it back to source and discharging it dollar for dollar. Okay, using the process, the 1099. Okay, which again, I've got a module on my course that you guys can go through that kind of breaks it all down for you in order for you to be able to do this, again, as a sui juris. Do your own tax returns, tidy up your account, be the one to execute your trust. Okay, and that's what they're looking for people to do, to actually help them out in that sense. You don't become an enemy of the state. You don't become a wall of the state. So everyone around here paying in debt notes is actually contributing to the debt, and it's creating the government more and more of a headache. It's creating more inflation, and it's just driving the whole economy in the world into the ground. And I think this is how they managed to bypass the karma, because it's actually the people, the foolery, the tomfoolery and the ignorance of the people, like it says in their maxims, ignorance is no excuse, of the law, in order to pin the karma onto the people, and like the people end up becoming the kind of engine towards destroying the earth. And through this system, it's a very cunning clandestine system they put together, but the remedy's there for us guys to come out from it and learning how to be protected, but learning how to operate in it too. Okay, like what David Miller said, learn to live and sleep in the world of fiction, and learn to live and sleep in the world of fact. Okay, you can't through just knowing the quantum grammar, through just knowing the UCC, those things alone are no kind of freedom tools. You need to integrate everything: trust law, contract law, these trust entities, 1099 process, exactly what's going on in the monetary system, all the status correction roles that we can play, and the papers that can back your ability to, stay protected in that and notify them, and the quantum grammar, the language fraud, as well as the UCC, which is very powerful given that everything's securities, and that's otherwise just a public platform to announce, what you're securitizing with your bonds that you can issue yourself, etc., etc. Okay, so very powerful. It's so important to comprehend, guys. So go over this multiple times. I think what I'll do, we'll just finish off this paragraph, and then we're going to open up, keeping on this theme of the money with what's going on in America. Likewise, anywhere you are in the world, if you have a central bank and your nation is under debt, and you can do this by typing in national debt calculator, you're under the same system. And the same jurisdiction applies with this in rem proxy legal fiction, colouring the law, trapping you into acting as trustee for all these legal tricks and traps and subrogation. Okay, it's no different. Okay, so what we'll do, we'll just finish this paragraph. Now I'm going to pull up David E. Robinson in order to elaborate on what's going on with this whole redemption process. Right, a statutory entity is inherently accountable to courts of civil legislative jurisdiction, deriving subject matter jurisdiction from the corporate charter, over which the legislature holds in rem jurisdiction as well by way of possession of the charter documents themselves. Whereas an express trust is obviously inherently accountable to courts of common law and equity, deriving subject matter jurisdiction from the trust instrument and corpus. As logic follows, in rem jurisdiction remains with the trustee at all times, unless the trust instrument and corpus are surrendered to a third party voluntarily. In rem jurisdiction, i.e. actual possession, is the key. Okay, so that is the key. When you're a trustee and you've got property held by the trust, you're in your own in rem jurisdiction because you're holding actual possession. Okay, and obviously key as well is to have the actual title of the thing, the true original title. Like in America, it'd be the manufacturer statement of origin or manufacturer certificate of origin. You need to get your hands on these things, guys, if you want to truly come out of the system and have that trust own that property. Okay, and then truly have that under in res jurisdiction under the common law courts of equity. Okay, where they can't then turn around and say, well, you transferred this vehicle from a bill of sale, you've done everything right, I can see that, but you don't hold a allodial title because you paid for it in fiat debt currency notes, and we still have the MSO, manufacturer certificate of origin, whatever the equivalent is, no matter where you are, you need to get your hands on that allodial title, that birth certificate. It's a birth certificate of that product that's been created, just like our live birth certificate, right? That's hidden somewhere. They hold a copy of that. Title's 1/10 of the law. It controls the other 9/10, which is all the in rem, the products. So I just want to read through this, like keeping on the theme of what happened around the 1933. So the redemption timeline, there have been so many papers written about the redemption process, and yet there seems to be a lack of understanding of the basic concepts. Redemption is the initial path taken by people who know they are free but see no hope in the judicial system as it is practiced today. It's vitally important to understand how the people and the government turned our lives upside down and have made us believe that we are subject to them, when in reality they are subject to us. Every being is part and parcel of we the people. So key points. 1. In 1871, the federal government formed itself into a corporation and pulled itself out from under the Constitution. America is particularly very important because because it's so rich in resources, and geographically that landmass is just massive. They've used America as the military arm for Manifest Destiny for the New World Order, which obviously over the last century they've just been going to war everywhere they can. Under the Confessions of an Economic Hitman, guys are trying to get them in debt, all these nation states. If they don't get in debt, then they send out the jackals, the CIA assassins, to assassinate the presidents, to put in a president who is going to basically bow down to the corporate charter of the New World Order. If that doesn't work, then they're going to set up a red flag herring event and send in the troops on the ground to go to war, which is what happened in Iraq and Afghanistan and all this. It obviously ties into the Stargates as well. So there's a lot of layers that can be interpreted based on the motives and agendas behind what we see on surface Earth with the things that they spin us in the media, right? So America is so important for them, so it's been the muscle in order for them to really roll this out and get things done and take over all the other nations that were still operating like a relatively common law, just kind of sovereign system. So second, in 1913, the Federal Reserve central banks were created. In 1933, President Roosevelt rewrote and reinstituted Trading with the Enemies Act of 1917. This applies only to 14th Amendment citizens of the federal United States. 4. In 1933, President Roosevelt took the gold away from the people, although they were not required to give it away, thereby leaving the people without money for paying their debts. 5. In 1933, President Roosevelt passed HJR 192 of June 5th, 1933, simply put, since the government had taken the gold and the people had no money, the government would pay the debts for the people dollar for dollar, thereby giving the people unlimited credit. 6, why when you do the accepted for value, you always do it for, off the back of your unlimited exemption, which is your unlimited credit, your ability to draw unlimited credit with this system, off the back of your life force, you even being here. And that's how they draw out credit lines and then go to the international banks and say, look, we've got another stock, another product here. This is the birth certificate. This being is going to make us a lot of money because he's going to pay a lot of taxes, because he's going to go through our educational system, the indoctrination camps, and he's going to have not one Scooby-Doo about what's happening. So we'll be able to make a lot of money off of him, which means that we want to take out new loans off the back of him, if that's all right, for us to then, fork out and pay and subsidise all these other corporations, which are lying in the same bed for them, in order to set up more businesses to capture more of the employees, which are just slaves, right? The EIN is the master, your social security number is a slave identifying number, in order to, perpetuate this fucking scheme that's going on. And the taxes just go to pay off the interest that's due on all the loans that they draw out off the back of your life force, your security, which is your birth certificate. Okay, so this is really what's going on, and it's crazy once you get your head around it, wrap your head around it. But like I said before, we have all the remedies and the solutions here. It's just a matter of coming into the knowledge. The truth will set you free, and knowledge will set you free too. Knowledge dispels fear. So just keep studying, guys. You will learn how you can access your limited credit to discharge every bill you have dollar for dollar, which is the pledge under this resolution that the government took, because they took away your ability to pay, backed by gold and silver. And instead say, hey, look, we're going to prepay for everything for you, dollar for dollar, under your limited credit. But they, obviously, with what they've done, they've subrogated, make you trustee, which has to pay the debt, which has to perform under the bankruptcy as an enemy of the state. So it's, once you realise, guys, like really just keep going over it until it, the penny drops, and then you rise above it all. It's so empowering, honestly. It's my dream for everyone to get to this point so we can start administering their own estates and holding these guys as trustees with the oath of office that they took. These snakes. Ophis in Greek is snake. Let's just look this up again. I think it's pretty. Ophis you look at the phonics of the words as well. This is from Pierce Sabac's work. Ophis is Greek for serpent. It may refer to the constellation serpents, Ophis. So yeah, office, Ophis, office. It's very similar. These snakes. You gotta make sure you're on paper, basically pledging them, or making them trustees on your behalf when you're executing your estate as beneficiary for you as beneficiary. So we carry on. Number 6, in 1938, Erie Railroad versus Tompkins made contracts the rule of law in courts. Everything's contract law. Everything's done by consent. 7, in 1946, we lost our government in courts through the Administrative Procedures Act. 8, in 1965, silver was taken away as a means for paying debt. The UCC became the supreme law for America concerning the banking system, and the courts were pulled together in an administrative, admiral, civil, contract or commerce corporation, and the act and intent were brought together, thereby taking away any plea of innocence. You have to now prove there was no intent. Guilty until proven innocent, changing the often quoted phrase, you're innocent until proven guilty. So there you go. Highly recommend you guys read that book, okay, just to re-emphasize those points surrounding this very pivotal time in history for humanity, infamous time. So we shall carry on. This brings us to today. In the jurisdiction of the 14th Amendment United States Public Trust, precious metal, the substance of the common law, is legally merely a commodity. Back in the Republic, however, it remains the staple for payment of debts. Through surface gold and silver are in considerably lesser quantity and without a fixed standard upon which to be traded. The express trust under the common law, holding real estate, silver or gold, is holding the very substance of the law under which it was created, thus ensuring that bond between law and land and the powers and guarantees that come with it. Okay, so that's, guys, that should be pretty self-explanatory. All right, we'll just read this footnote, number 31. It should be noted that through the express trust, though the express trust is created under common law, it is not a creature of the common law as distinguished from equity, but rather it is created under common law contracts and not dependent upon any statutes. Equity supplements the common law. Okay, it's an important concept. And though the trust may bring an action in admiralty, it is not inherently accountable to that jurisdiction. And just to supplement you guys again, I'm just going to read through chapter 13 here. So it pretty much gives you a good breakdown of common law, equity, and maxims. So you've got, the 10 maxims of law here. You can read through that in your own time. Very universal, all quoted in the Bible, mentioned in the Bible. Bible, the courts and these guys have declared the Bible the Word of God, and this is how they based all of the common law. Okay, and the law merchants under, which you can quote, look up in your own time with the the verses that have been quoted. So number 13 is going to just give us more emphasis towards and behind the common law and how it's still linked to the law merchants, and that equity. When we see equity, the closest thing to equity that we can refer to is otherwise maxims, okay, in law. So when Jesus spoke the truth to his accusers, he would justify himself by quoting the law. First, he would quote God's law, and after quoting God's law, he would often quote the accuser's law and use that against them as well. For example, Jesus would say, "Did ye never read in the scriptures? and then quote God's law. Then he would turn around and say, is it not written in your law? And quote their own law. His accusers would have no answer. They could not overcome him. How could anyone overcome somebody who is obeying both God's law and man's law? If a man-made law is just, it will be in harmony with God's law, the basis of common law, right? So this is the purpose of this chapter. These maxims are the foundation and principles of the laws that man passes today. Unfortunately, men enforce their own will more than they enforce law. So this is why, in addition to knowing God's law, it is also important to know man's law as well, because man's law is based upon God's law. And when you are accused of breaking the law, you can do what Jesus did and use both God's law and man's law to justify your lawful acts. For this is the only thing that will excuse you. Maxims of law are not commercial law, but are mostly based upon scripture and truth. Okay, so it's very important to realize, guys. Maxims of law are not commercial law, but are mostly based upon scripture and truth. And because they declared the Bible the word of God, when you come in quoting maxims, which is why you see in my declaration, mistakes correction package, it's such a simple document, very, very powerful. When I'm making these quotes such as I want to be treated innocent until proven guilty, I want to come out from their bankrupt jurisdiction, and I quote all these maxims, which some of them are, some of the 10 maxims of commerce, which are listed here, maxims of law. Very, very important to quote these and have this, in your status correction documents, and your ability to put pen to paper as a sui juris and tell them how you wish to be treated within the system. Here is a court case which demonstrates a typical example of the fruitlessness of describing oneself in the terms of the world as distinguished from whom and what our Heavenly Father has told us we are. It was rendered by John versus Parker, Chief Judge. Petitioner's shield of the common law as an unenfranchised sovereign individual of the United States of America, a republic, provides him with the same degree of protection from federal income taxation as did the ghost dance of the Sioux warrior from the repeating rifles of the federal cavalry. Zero protection. Okay, pretty self-explanatory. But note, the real issue here is not who the petitioner is, but where he is. The real issue here is a matter of jurisdiction. The petitioner must make a distinction between the territorial United States and the for-profit United States Corporation. Subject matter jurisdiction, so very important. Many insist on using the common law to defend themselves. The reason we should not is because, first and foremost, you do not see the term common law in Scripture. Bondservants of Christ are only to use God's law. Secondly, the common law is a commercial law today, created by merchants, influenced by Roman law, and used for commercial purposes. The following definitions are taken from a Dictionary of Law by William C. Anderson, 1893. Custom of merchants. Okay, this is just going to prove what he claimed above about how common law is otherwise under the law merchants. A system of customs originating among merchants and allowed for the benefit of trade as part of the common law, page 303. Law merchant, law of merchants. The rules applicable to commercial paper were transplanted into the common law from the law merchant. They had their origin in the customs and course of business of merchants and bankers and are now recognised by the courts because they are demanded by the wants and conveniences of the mercantile world. Roman law, the common law of England, has been largely influenced by the Roman law in several respects through the development of commercial law. All of man's laws, except for many maxims of law, are commercial in nature. The following are the definitions of maxims, and then the relevant maxims of law will be listed. Okay, so maxim, Bouvier's Law Dictionary, 1856, an established principle or proposition, a principle of law universally admitted as being just and consonant with reason. 2. Maxims in law are somewhat like axioms in geometry. They are principles and authorities and part of the general customs or common law of the land, and are of the same strength as acts of parliament when the judges have determined what is a maxim, which belongs to the judges and not the jury. Maxims of the law are holding for law, and all other cases that may be applied to them shall be taken for granted. 3. The application of the maxim to the case before the court is generally the only difficulty. The true method of making the application is to ascertain how the maxim arose, and to consider whether the case to which it is applied is of the same character, or whether it is an exception to an apparently general rule. 4. The alterations of any of the maxims of the common law are dangerous. It says here maxim in William C. Anderson's Dictionary of Law, 1893, page 666. Wow. So called because its value is the highest and its authority the most reliable, and because it is accepted by all persons at the very highest. 2. The principles and axioms of law, which are general propositions flowing from abstracted reason and not accommodated to times or men, are wisely deposited in the breasts of the judges to be applied to such facts as come properly before them. 3. When a principle has been so long practiced and so universally acknowledged as to become a maxim, it is obligatory as part of the law. We got here Maxim and Law, Black's Law Dictionary, 3rd edition, 1933, page 1171. An established principle of proposition, a principle of law universally admitted as being a correct statement of the law, or is agreeable to reason. Coke defines a maxim to be a conclusion of reason. He says in another place, a maxim is a proposition to be of all men confessed and granted without proof, argument, or discourse. Okay, in Black's Law, 4th edition, maxims are but attempted general statements of rules of law and a law only to the extent of application in adjudicated cases. These maxims are taken directly from Man's Laws dictionaries and called cases. The following books were referenced for this chapter. Okay, so then he goes on to categorize alphabetically, given the subject matter jurisdiction, right, or the subject at hand, given any cases like accidents and injuries, for instance, and then benefits and privileges, all the maxims associated to cases that have been dealt in the past, that have been quoted and otherwise derived from scripture. Okay, that you can go through. It's like a glossary, an index in the back of the book, which I highly recommend getting and supporting this guy because it's tremendous, this little book that he's put together, okay, which is called Be the One to Execute Your Trust. So there we go, guys. I hope that added even more explanatory depth and more spokes to your wheel, as it were, on this journey. So yeah, very, very important to, understand, overstand, and understand. Right, we might as well power through. We'll get through the certificates and the trustee basics, and I think we'll come back in for another video, a part two. Okay, so certificates. What may come as a surprise is that any trust may divide its trust property into shares and issue certificates. The power to issue certificates and bonds and employ the use of an official seal. Very, very important. Okay, so let's go down to number 35. The reason why we make our own seals under the seals, emblems and crests module is again re-emphasized here. As a side note, the right of an individual using a seal has never been challenged based upon the universal understanding that it is used as a matter of right. Once the trustee has adopted the seal and has used it, it is automatically presumed that the use is lawful until proven otherwise. Okay, and so the main importance and the reason why we're doing this is because everything's treated as a vessel as well. Your documents and even your envelopes, even your house and your car and your person. Which is why, when we're going around, we're gonna make sure that we're carrying our seal. As you can see here, with the my private identification, where you can see Homo Liber there. There's my seal. That's my court of office seal, as well as my ministry 508c1a I have set up. There is the seal. So any of the vessels that I'm administering under these entities, whether it's myself or on behalf of the ministry or on behalf of my trust, I always put on the letterhead my seal. I always end when I do my autograph with my seal. Okay, we have a personal seal, which is our thumbprint or fingerprint, so it's unique to us. It's otherwise a two-dimensional representation of our three-dimensional self that has all of our weight behind it. It's a graph of our autonomy. Okay, then also on the envelopes, when I print out the envelopes, I make sure I have on the top left a flag that is flown on that vessel, which is an envelope, when it is sent through the shipping lanes, the post of road mechanics, as the vessel it is floating in the sea of space. And then on the reverse, where it's sealed, I put my stamp too, which is my flag, my seal. Okay, so very, very important, guys, to make sure you're following the proper protocols of the maritime jurisdiction of sending and receiving your vessels, which are otherwise your documents, docs, for your volition of your mind to put pen to paper and then send it through the sea of space. Okay, which is what Earth has been captured as. It's just another vessel floating in the sea of space, which it is. Once you know how to play the game, you can become master, postmaster, and captain of your document. Your documents, your docs. You can become the dock master, and the postmaster, and the captain, the master of your vessels. Okay, so that's the key. You've got to become the dock master, and the postmaster, and the captain of the vessels you wish to navigate in these open seas. So we continue. The power to issue certificates and bonds and employ the use of an official seal never has been restricted to corporations. It is well settled law that whatever else most corporations possess beyond their artificiality and right of suit in a corporate name is a mere incident or consequence of incorporation and not a primary constituent. In fact, most attributes now commonly held as corporate in nature, such as the power of issuing transferable shares, limiting liability of offices, using an official seal, making bylaws, purchasing lands and chattels, are merely the legislative recognition and adoption of natural common law rights any man or woman sui juris may exercise without permission, much less a charter from the state. The court in Warner versus Beers clarified this principle most effectively, and it states, there are several very useful and beneficial accessory powers or attributes very often accompanying corporate privileges, especially in moneyed corporations, which, in the existing state of our law, as modified by statutes, are more prominent in the public eye and perhaps sometimes in the view of our courts and legislatures than those which are essential to the being of a corporation. Such added powers, however valuable, are merely accessory. They do not in themselves alone confirm a corporate character and may be enjoyed by unincorporated individuals. Such a power is the transferability of shares. Such too is the limited responsibility, liability. So too the convenience of holding real estate for the common purpose, exempt from the legal inconvenience of joint tenancy or tenancy in common. Again, there is the continuance of the joint property for the benefit and preservation of the common fund, indissoluble by death or legal disability of any partner. Every one of these attributes or powers, though commonly falling within our notions of a moneyed corporation, is quite unessential to the legality of a corporation, may be found where there is no pretense of a body corporate, nor will they make one if all were combined without the presence of the essential quality of legal individuality. Okay, so the trustee of an express trust is empowered by the terms and provisions of the trust instrument to issue certificates not only of a beneficial interest but also of capital interest. Okay, we'll just quickly see here what he means by that. Also referred to as trust certificates or certificates of trust units. Okay, and then for the capital, also referred to capital certificates as certificate of capital units. Okay, and this is basically just a receipt for exchange of either capital or property, whether you're going to be an outside investor or someone actually comes in as a beneficiary of the trust. You'll be a holder of these so-called certificates. So, generally speaking, beneficial interest is that which is held by the beneficiaries of the trust who is entitled to a certain proportional share of the trust assets during the life or at the termination of the trust. Or capital interest is that which is held by the exchanger or exchangers who has invested property into the trust and thus becomes entitled to a certain proportional share of any profits and assets remaining at the termination of the trust. As a rule, the terms and provisions of the trust instrument control the manner in which beneficial and capital interest are to be administered. It should define the rights of interest holders who, incidental to their acceptance of the interest, are bound under the trust instrument to that extent. But there are certain principles which govern these interests in construing the fundamental classification of the trust. For instance, it is held that where the certificate holders have control over the trust property and or administration of the trust affairs, the trust arrangement is, in fact, a partnership in which the shareholders become liable for the acts of the trust. It says to see the court case down below. The basic principle is that if it is free from the control of its interest holders, then it is an express trust. This is commonly referred to by courts of equity as the control test. Okay, so this is very important. Then before you got all the court cases here, okay, in which control must ultimately rest with the trustees of the trust in order for it to be properly classified as an express trust. Okay, if you remember a corporation, the way it's set up, you've got the executive, the directors, formulate the corporate charter, the bylaws, terms and conditions of that corporation. The trustees are its employees, and then the beneficiaries are the shareholders, the stakeholders. Okay, and they've got equitable interest in the property in the company, and they're deriving profit from that, which means that they have a say in being able to vote on the boards as to how the company is managed. That would not pass the control test because that is defined as a corporation. And so when you issue these certificates of beneficial interest and capital interest in the indenture, and obviously on the certificates it particularly stipulates that it doesn't mean that possessing this certificate means that there is no control or power granted on behalf of the holding this certificate. It merely shows proof that you have a share in the trust's benefits, which is purely based on the discretions of the trustees, who hold all the power of decision making and being able to vest benefits and interest into those certificate holders, okay, based on whatever it is they do for occupying and administering the trust. The well-settled principle applied by courts of equity is that interest holders, by full legal title and control over the trust property being vested absolutely in the trustees, cannot be considered partners nor agents, and therefore cannot be held liable for the debts of the trust in that manner. Furthermore, the certificates have no determinable fair market value, and therefore no gain or loss is recognised until the cost or other basis of the property disposed of has been recovered. In Commissioner of Internal Revenue versus Marshman, the court held that fair market value is determined by property received by the taxpayer, not the fair market value of the property transferred by the taxpayer into the trust. What's more is that certificates are considered not necessarily as chattels, but as documentary evidence of ownership and intangible rights, and in and of themselves they are only personal property, not the actual interest or share itself. The interest in express trust cannot be traded without the approval of the trustee. This is contrasted with the certificate of stock, which courts have long held may be dealt with in the market as a commercial document of value. Okay, so just really re-emphasising what I just mentioned there about the corporate setup and the trust setup. You're going to make sure these certificates does not grant any powers to the holders of those certificates as beneficiaries, okay, and or capital certificates from exchanges. It's purely there under the discretion of the trustees. The trustees hold all the power still. You're not giving away a share of the business or the trust. It's merely just representing that you're in line to receive benefits from the trust as and when the trustees decide to dispense those benefits, and it can only be taxed when those benefits are realised in their fiat currency. Okay, so the trust can also pay out gold and silver, in which case normally that's under a private contract. You might be able to divert the taxes that will come due on any capital gains as a result of any dispensations or selling of property. Okay, but when you have the property and you put it into the trust and in exchange you get the beneficial interest certificate, because there is no value assigned to the transfer and the transaction, which is what a conveyancer or surveyor comes in to assess, because he's there to assess how much the property is worth, thus how much tax we can make off this transfer, which is going to go to the international banks to line their pockets, means that because there's just an assignment of how many trust units of these beneficial interest certificates are exchanged, there is no value for them to assess, because it's being exchanged for those trust certificate units and not Federal Reserve bank notes, these fiat currency debt notes. Okay, so that way you can bypass any taxable event. However, but when you do come to liquidate and maybe sell these assets held in trust or dispense profits, well then that would be based on the beneficiary in terms of capital gains had or any income derived from that. If it is paid out in fiat debt currency notes, that individual will have to deal with the tax agencies and declare that. Okay, but like I said before, once you come under the right status, correction as tax exempt status, and learning how to operate in the public side, even with the holding companies and all these disregarded entities that can then pin their income onto you as an individual that is tax free, sui juris, a natural living man or woman that can't be taxable, you've got unlimited liability. Okay, then you will be in a position where you don't have to be taxed at all. Okay, and basically tell the tax agency to bugger off, which you would have done if you had your status corrected and sent in all your papers. Okay, so really important concept there in order to divert the tax agencies, but do everything still lawfully and keep track of the beneficiaries and what they're entitled to based on how much of the trust certificate units they have sold. Normally it's 100. Okay, so it's a split of 100. Based on that, you work out who should get what based on what is in the res of the trust, what property is held in the trust, and what kind of income is derived from that. We'll then obviously calculate who gets what based on how many beneficial interest or capital interest certificates they hold. So, trustee basics. Let's just go through this, and I think we'll call it. and then pick up where we left off for powers and duties of the trustee. So, first and foremost, anyone, man or person, capable of taking physical possession of or legal title to a property can be a trustee. Even a thief, so we look down in footnote 54, even a thief is considered by operation of trust law to be a constructive trustee. And there is no limit to the number of trustees who may serve in any one trust. Generally, where there is more than one trustee, the trustees with respect to each other are referred to as co-trustees, and when acting jointly as a collective body are referred to as the Board of Trustees. Furthermore, there is no law prescribing the character of a trustee, and while it has been held that a trust cannot be invalidated simply due to incompetence, the trustee should be at least someone capable and fit for executing the powers and duties honourably. This is the basis for the general rule that beneficiaries are not desirable as trustees, though there is no law to forbid such appointment. You'll see, there are some trust examples where you come in as a trustee and you can also be a beneficiary, but I'd advise against that, because you can pretty much benefit from it just being the trustee, and then have your kids down as the beneficiaries. You can have anyone down as a beneficiary. You can have the general public. If the trust that you set up is going to be dispensing information, education on the public platforms like YouTube, or you have a website, then you can actually list down the general public as members, as beneficiaries to your trust, and that any money that you organise, a property that you organise as trustee, you'll be compensated for. Like I said, with the documents that we went through in the previous videos, up to the value of $500 a day is considered justifiable compensation for a trustee in order to do his job, to discharge his duties. Right, and that's tax-free. So it's protected under the trust. It's a private trust agreement between you and the trust. That doesn't have to be disclosed, okay, to the public. So equity will generally avoid all temptation to a breach of trust. The trustee shall be stationed within the jurisdiction of the court of equity in which the estate is located, if indeed the trust corpus is an estate. But where the trust corpus is portable land, i.e. gold and silver, the trustee need not be stationed within any single jurisdiction. Non-residency will not disqualify or preclude the trustee from carrying out his position. So as far as accepting the appointment is concerned, this should be done formally, expressly in writing, even though it will always be implied if the individual intermeddles with the trust property or performs any act to carry out the trust. Once acceptance has been tendered, no court of common law equity can prevent the trustee from holding that office except for breach of trust, or good cause dependent upon clear and lawful necessity. Removal must be procured pursuant to the provisions of the declaration, or where no such provisions are made by decree of a court of equity. Lastly, it should be noted that the office of trustee is not always a desirable one. When the trust instrument conveys a burdensome obligation, the trustee is miserable and at risk of breach by failure to perform. When the trust instrument has been constructed poorly, the trustee is miserably confined and inhibited, and he may well be held liable for trust contracts with outside parties. The trustee has a duty of care toward the beneficiaries and must harbour no biases or resentment in administration. Therefore, it is prudent to empower the trustee with enough discretion to carry out his position to the best of his ability and responsible creativity. To put it plainly, the settlor must truly trust the trustee to carry out his duties and use his powers justly. That's the whole role of a trustee, right? It's to keep secrets. Keep secrets, these secret contracts that are beholden in the private. That's where our power is. Let's just go up here, footnote 48, Seamaster Tax Guide. In regard to capital certificates, the courts have long upheld the doctrine of exchange, and that certificates in exchange are not taxable until a realised gain has occurred. Okay, so when that realised gain has occurred, that's when our status correction knowledge steps in order to be tax exempt. Okay, or do the 1099 OID process of returning whatever is gained back to the source and accepting for value anything that might be taxable, using your unlimited exemption, your unlimited credit that was bestowed upon you by the government when they took away substance as collateral for debt in exchange for security. So let's look at 55 as well. This term is sometimes used to denote the co-trustee has less authority than the trustee. So we'll just go up here, just briefly look, so in relation to co-trustee. But express trust usually employ the term co-trustee simply to denote that there are several trustees of that trust. Okay, it's pretty straightforward that. So there we go, guys. what I'll do is, we'll take a break and I'll make another video and we'll continue on through this PDF where we're going to go through powers and duties of the trustee, privileges and liabilities of the trustee, okay, and then authorised representatives, how to contract for other people, express trust versus corporation, so we've got a lot to look forward to, understanding commerce, again, which breaks down the game that's being played, which is really, really good, doing business, okay, so again, making sure that we don't fall under the jurisdiction of being, beneficiaries and taking privileges as part of their system, which can bring the trust under their jurisdiction in res. And limiting liability and risk, okay, which is all very important, banking too, and then transferring assets, and then we're getting to the end, issuing certificate and bonds. It's a lot, but you need to know these things, keeping up the minutes of the meetings, prevailing in legal affairs. So this we can skip unless your trust is in problems, but if it's administered and set up correctly, you're not going to have any issues with any legal matters unless you self-sabotage. But we can read through the highlights at least. And that pretty much sums it up. There's a great part ending with the IRS relations, maintaining proper IRS relations, breaking down the tax, and again, what's going on with the banking system and the monetary system. And some great references and quotes there by some good statesmen like John Maynard Keynes. And the conclusion, and then obviously goes into the sample forms that you have, which are basically on the private side. There's a few here that are on the public side, but as you'll see with the documents I share with you guys under the course, you'll see, which we'll just get up right now. So if we go into this is why this document is such a really good complement to the work that's already been done surrounding asset protection, estate management, estate planning, because you'll be able to see the power behind these trust templates and the public trust templates. Okay, so this is a declaration of private trust. People pay lawyers anywhere between $5,000 to $10,000 to have something like this drafted up. Okay, and this is generic, and this will achieve everything you need to achieve in order to have this entity set up. And you've got access to all of this, people on the course, certification of execution of trust, abstract of trust, minutes of the trustee meetings, executed and accepted as trustee. You've got the second trustee, notes of beneficiaries, okay. And then on the private side, this is otherwise what Carlton Weiss has shared. You've got the hold harmless indemnity agreement, security agreement, beneficial interest certificate, promissory notes, mortgage, grant deed, quitclaim, independent worker agreement, okay, which is very similar to what he has put down here, just labelled slightly differently. You've got indemnity bond, independent contractor agreement, okay, even shows you how to obtain an EIN to open up a bank account linked to the trust, okay, which is very beneficial. And all the other things that are needed in order to organise this yourself, okay, in becoming a sui juris. So it's not for the light-hearted. It's not for people who are kind of 1 foot in, 1 foot out with wanting to be sovereign. I think a lot of people in this movement, have this idea of sovereignty in their heads and not realising the amount of knowledge you need to know in order to get to that point and qualify yourself as being a sui juris, a sovereign, okay, where you can actually administer your own affairs, set up your own court of office. But this is why I put this course together, because it will walk you through step by step in being able to get there as quickly as possible, which will trim all the fat of all the unnecessary noise that otherwise is out there from a lot of other gurus, and just focus on what needs to be done. Learn the post road mechanics, learn how to operate your vessels in commerce, which is your envelopes in your documents and anything else that you move, your own being, through status correction. Make up your own seals as part of your court of office. Learn about trust law, learn about the Bills of Exchange Act, learn about the monetary system. Okay, then come into learning about the asset protection and estate planning through these entities that we can set up, and also through the 508c1a ministry, which some may argue, and from my research, is a lot more simpler to manage and set up, which is otherwise like a private entity but recognised publicly. So it's a very powerful entity. I think a lot of people on this journey as well have referenced that 508c1a is the best thing to set up, in that regard in order to operate, but there's take no power away from this. This also is so very powerful to set up. Okay, these trusts that last for 20 to 21 years. So you want to go against the laws of perpetuities, and then you just have other trusts set up, and in the indentures, the declarations, you can have it, you know, siphoned off to the next trust you set up when 20 years is up. And it just means that you'll be protected from these vultures who are trying to sue you based on the fact that you can't have an entity like this which can exist for perpetuity, so those will be labelled as a corporation. The only entity you can have that's similar to a private trust that can exist in perpetuity and not be labelled as a corporation, still have tax exempt status, is a 508c1a ministry, church. And it's not a trust. There's a lot of guys out there trying to sell it as a ministry trust. They're two separate entities. A trust and the ministry are two completely separate entities, which are defined in the tax codes. So you must come in as a 508c1a church and not a trust, and you'll be able to administer it. And it's a lot easier. So I'll do another video, obviously breaking down. For those in the course, it'll be inside. This won't be public knowledge, it'll be private knowledge. Possibly, I don't know, we'll see what I kind of reveal on that. But comparing the 508c1a ministry to the common law private trust, or the express trust, as Carlton Weiss refers it to. Okay, and then you'll be able to see what kind of work is needed to administer the private trust, and what documents are needed to formulate and set this thing up compared to a 508c1a. You'll notice that there's a lot less things to tick off in order to administer your 508c1a ministry. Okay, so that being said, guys, thank you so much for being patient and sitting with me and going through this. I hope it's been very educational. Recommend you guys, again, print it off, a hard copy, read through in your own time, and then obviously watch this video multiple times too, listen to it with audio when you go on walks, whatever, and just let it sink in, and it will all fall into place, and you'll begin to see the power behind these things. And it's so important to have this knowledge set up, because, you know, when you come into, you know, actually redeeming the wealth that is owed to you through the 1099 process and stuff, once you know, crack that code and set up your Treasury Direct account, where you need to have vehicles in place to protect your wealth and assets when you do receive them, when you build your wealth, so then you can create a legacy that you can then pass on to your children, intergenerationally, and their children's children, etc. Okay, so yeah, thank you so much. Hope this has been of value to you guys. I wish you all the best, many blessings. Keep studying hard. As always, stay safe, take care, and stay sovereign. See you in the next video. Ciao for now.